Good afternoon, everybody. This is Dave Honecker from LexisNexis, and welcome to the LexisNexis Law Firm Practice Management Thought Leadership Webinar. Everybody say that 10 times fast. Today's CLE topic is Model Rules for the Modern Lawyer, Leveraging Technology to Follow ABA Guidelines. I'll be your moderator for today's session, which is going to work like this. You're probably familiar with it. 50-minute presentation followed by a 10-minute Q&A period. Now, everyone's going to be in listen-only mode, so questions you have will be answered at the end of the webinar. So when you do have questions, just use the question box located on the GoToMeeting toolbar. So, without further ado, I'll start by introducing our speakers, Christopher Anderson and Jeffrey Taylor. Chris is an attorney, practice management expert, and legal technologist. He's authored numerous articles and speaks on a wide range of topics, including law firm management, the ethics of cloud computing, and the future of technology and law firms. A regular speaker at Legal Tech New York, ABA Tech Show, and various state bar associations, Chris has over 19 years of experience as a practicing attorney and is a former managing partner of a full-service law firm in Georgia. He's also served as in-house general counsel and began his career as a New York City assistant DA. Jeff is an attorney and blogger at The Droid Lawyer, one of the ABA Journal's top 100 law blogs and one of BizTech Magazine's top 50 must-read IT blogs. The Droid Lawyer is dedicated to helping lawyers understand the Android mobile operating system and how to use mobile devices in their law practice. He's a solo practitioner in Oklahoma City and frequently talks to bar associations and firms on the value of mobile operating systems, cloud computing, and SaaS systems for lawyers. So with that, I'll turn it over to Christopher Anderson and Jeff Taylor. Take it away, guys.
Thank you so much, David. Really appreciate the introductions and really appreciate the opportunity to speak to the folks on this call. So hello, everybody, and Jeff, I'll let you say hello as well.
Yeah, thank you very much. I appreciate it as well. This is an opportunity that I love doing, and I'm grateful for the invite to be able to talk today. Today, when we talk about the modern rules, we sometimes need to ask what the rules are. I think a lot of people are understand the basic ethics rules and the environment that we discuss, and so what we need to talk about though is getting deeper into those rules, and basically we talk about two kinds of rules. The first rule is the confidentiality portion of it. This deals with how we handle information, and we're familiar with Rule 1.6, and specifically, I think all of us know 1.6c, which basically says a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of the client. Now, there's a big question as to what that means. But basically we look at it and we say, hey, look, it's reasonable efforts. And so there's still some aspect that we don't understand. I don't really know what reasonable efforts is, but it's mainly defined by your bar association. But I think it involves knowing what the technology is, knowing how it works, knowing what the requirements are, and knowing what's going to be the best outcome for your client and help your clients get to that outcome. I think
what can be really interesting is that a lot of lawyers, when faced with what's a reasonable effort with the files that they've got sitting around their office, or even if they're carrying floppy disks back and forth, or they're carrying stuff in their briefcase back and forth to court, everybody kind of has a good idea, or when they're archiving stuff in their basements, lawyers tend to have a pretty good idea of what they think reasonable efforts are. But inject technology into the question, everybody gets all James Bond about it.
Yeah, exactly. And I think that's the confusion where everybody is. We all know that we're supposed to keep our documents protected, and we're supposed to use locks on our doors and store client information in lock boxes. But then when we say, okay, well now we're going to start using computers. Well, that's a whole new realm of involvement, and that includes understanding if you're going to be using the Internet, what's required on the Internet to protect that inadvertent or unauthorized disclosure. Technology is really changing the way that we look at how we do business and how we as lawyers act ethically under those constraints. One of the things I hear a lot is that I don't use a lot of technology, so I don't really need to abide by those rules. And I think that's a shame and a farce, because we all in some way use technology, and the closer we are to year 2020 or so, I think that a lot of us are going to be all computer and no paper as far as court systems and a lot of environments like that. I don't know what you think about that, Chris.
Well, I think that's. I mean, unless a lawyer can honestly tell us that he's using a pen and paper and doing this by candlelight in a building made of grass and straw and mud and whatever. I mean, the era of the Luddite, the era of running away from technology or ignoring it, is really just an era of hiding from the truth. From the truth that every time you pick up a phone these days, every day you pick up a cell phone, your communications are being converted to digital and are being moved across a data network. Every time you send a document by email or by fax or it's all being digitized. It's all being sent across a network. And hell, we just had articles out today on the New York Times about how the post office is in fact tracking our communications, logging to and from addresses, and keeping and building databases about who communicates with who, how frequently, et cetera, et cetera. So I think to say that technology is not having an impact, or to say that I don't use a lot of technology, is certainly is hiding from it. But so the question I would put to you, Jeff, is how do lawyers stay current on the world of technology as it applies to legal, so they can stay current and understand better what that reasonableness standard means in context?
Well, I think the basic thing that lawyers need to do is there's going to be a CLE aspect, attending seminars like this, attending local bar association meetings, even national events, and also to read and understand where it is. One of the things I like to talk about when I talk to lawyers is the other duty we don't really listen to, which is Rule 1.1. 1.1 keeps a rule requirement that we are competent in our representation and our client relationship. Now, if we're using technology and we're not competent in how it works or how it operates or what's required to keep us safe, then I think we're violating one of the basic rule, the first rule of the model rules. Our competence. There's a thoroughness and a preparation. If you don't understand where your data goes when it's being sent by email, that's not being thoroughly prepared and being competent about what you're doing.
Right. And if I recall correctly, the American Bar Association in their Ethics 2020 submissions made a recommendation as to the model rules regarding Rule 1.1. That competence is now not just being competent in law and even just competent in the technology that you use, but they actually added language that said that you should be competent in the available technology, so that failure to apply technology that could have better secured your obligations to your client could also be a failure to abide by this section.
Yeah, that's exactly right, and I think that's a good point. I like this picture because it's playing with fire. If you're going to start playing with technology, or you're not there enough, you've got a duty. The minute you pick up a smartphone and you decide, I'm going to start using a smartphone for my law practice, you're playing with fire, and you need to know how to use that and what the obligations are. The minute you start using a telephone to transmit information across the telephone lines, you're playing with fire, and you need to understand the obligations. You talked about duty to competence. The part of the requirement is, and part of the problem where we saw lawyers start to see a lot of pressure was from clients. They started yelling at the lawyers that you're doing things, it's costing too much money, you're not doing it fast enough, you're not doing it correctly, and so we've seen a real pushback from clients to do things differently than we've done in the past. Again, I think we're going to see, as we approach the 2015 and beyond, we're going to see a lot more clients that are more tech savvy than we are, that know and use and understand and appreciate the value of doing things by email rather than by by letter and doing things by scanning documents and sharing documents through services versus making copies and sending them by the mail.
So let's take an opportunity then. So you're listing a few of them, but so if we say that competence is being aware of the available technologies and using them to best secure your obligations to your clients, what are some of the technologies that you'd recommend that attorneys in practice, particularly in small or smaller firm practice, use on a daily basis to really meet those obligations? What are some of those? List some, maybe the top 5 or 7 technologies that attorneys really should be familiar with, competent with, and that help them serve their clients.
Yeah, I think number one, if you're not, email's got to be at the top of the list. If you're not using email to communicate and share information as quickly as possible, then you're not doing your clients a service. And you can share that information and get it through as in a matter of seconds versus a matter of days or weeks, depending on how the method goes and where they're located. That's a big disservice to your client. Scanning, becoming more paperless, and using less paper in the office is a big advantage for small firms. To be able to get all the documents and store them in a digital format versus having boxes and boxes of documents stacked up. That gives. I saw an article today on becoming more of a mobile lawyer and being cheap, but being cheap in the fact that you utilize technology to be able to work anywhere and to do it. One of the things they talked about was scanning and using documents in an efficient manner. The other thing they talked about was using cloud providers. We can leverage, and we're talking about leveraging that product that way, but cloud is huge. Being able to get into the cloud and leveraging it through the cloud services, that's a big advantage. One of the things I like is legal case management. That's a cloud service that basically functions as your manila folder or your red roper that gives you the access to information, the integration, the ability to see everything, and to be able to put linked topics together and link individuals together. Yeah. I also like cloud services just in general for sharing and storing information.
Yeah. And so, yeah, just a couple comments on this, because I think that's a great list. On the paper list, I mean, people, you take that model rule 1.1 on competence, and you say that it has to do with, also being familiar with and competent with the available technology. Let's think about paperless. And let's think about my law firm. When I first got with a couple of attorneys who've been practicing for quite some time, and we started working together. One of the things that I discovered was their method of storing and preserving their clients' documents of client property, the safekeeping of their client property, which is another ethical obligation. And they, like so many other lawyers in the towns and cities that I visited, stored this client property in basements, in attics, in hotel storage facilities, in self-storage lockers, et cetera, et cetera, et cetera, which is all well and good, and it probably served and met the obligation 30 or 40 years ago. But these are all places where the documents exist in one place. If there is a fire, or let me just list the things I've actually seen. If there are rats that have eaten through the file folders, if there are other animals or whatever that have defecated or urinated on the file folders, which are in these storage rooms unattended for long periods of time, if there's a flood, if there is a leaky roof, those are the things that I've actually seen happen, not a list of all the things that could happen. I mean, theft could be something, a building could collapse, blah, 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 blah. The point being that probably met the obligation then, but being aware of today and being familiar with current technology where you could scan most of this stuff and not only have it stored on your servers, or maybe you choose to or maybe you don't, or have it stored in the cloud, but then to know that it would actually be backed up into independent locations simultaneously so that any disaster that befell this data in one place would not render it all gone in the other place. knowing that that technology exists, I think, and failing to use it could start to run you afoul of these new obligations imposed under the ABA model rules. And I think lawyers really need to be aware of them when they say, I'm hiding from technology. The answer is, well, you can't. It's unethical to not be aware of and to implement technology.
I fully agree.
Yeah.
I think, we got the cloud here, and people are afraid of the cloud because they don't understand what it's doing and how valuable it is. But what you've got is a resource, sometimes in a single spot, but usually, depending on the provider, your data is carried throughout different spots throughout the world and throughout the country where it's stored and housed and backed up and protected. And you can access it anywhere and be able to grab that information. Realistically, the cloud isn't any different than what we were talking about with big businesses, 5 or 6 years ago, where you have multiple locations and you can access the information at the business at any location that the business has. That's just a wide area network. The cloud is essentially the same thing. You've got a storage hub that any device or anything can access. And I think you're exactly right. The fact that you can take a 1,000-page medical record like I've just done and condense it down into a couple of 100 megabytes of information and then put that up in a storage facility and not have to keep that stacks and stacks and stacks of paper anywhere, it gives you advantage to be able to go anywhere and do anything and protect that information. There's also the requirement, part of using the technology is knowing that once you start using that, looking at that information, you've got a duty to protect it. Well, with the cloud, choosing the right provider, the providers are protecting that information. They're backing it up. You don't have to worry about that. They're doing that, and as long as you make sure that they're adhering to certain protocols and certain requirements of your state or of your practice area, then you've got that protection. That's their obligation, and you can worry about one less thing than having to tackle that matter.
And I think that's a great point, Jeff. That's one thing I think I'd like to elaborate on for a moment. Is I think part of the fear of the cloud, and I think first of all, let me state that here in 2014, almost 2015, I do think we've crossed the point where people are saying that the cloud is not where legal information should be stored. Dave and Kelly, let me ask you to go ahead and mute. We're getting some feedback from you. Okay. So what I'm suggesting is that that is gone as far as the fear of saying we can't use it. But I think where people get a little bit hung up still is the cloud has become the shorthand for what the technology is. And because what it suggests to people is that their data, their clients' confidential data is being put up sort of in the universe and going out there, and nobody really knows where it is or what it looks like or how to get it back. And that is so far from the truth. So I think I'm just going to spend like 2 minutes talking about, first of all, the two differences between public cloud and private cloud, and then just saying what the cloud really is. So first of all, public cloud versus private cloud is very simply, public cloud is using services like Google Docs, like Microsoft OneDrive, like Apple's iCloud service, and like so many others. Amazon's S3, there are so many. But where you're storing your data along with other people with vendors that provide this as a service in the public cloud. The private cloud is the same concept, except you're securing your own server that is being hosted either by yourself or by a provider, but it's yours, and you're not sharing it with other people, and you have private access to that. Both can be useful. But the point being is that the cloud is not a nebulous, non-existent, ephemeral thing. It is concrete. It is servers that are located in places that you can determine through your contract with your data provider. Some data providers are going to tell you, well, it could be in lots of servers all over the world. Some data providers will say, like our hosts here, LexisNexis for a Manager, we're storing this on Amazon servers here in the United States. You can get specificity, and know exactly where your data is, exactly how often it's backed up, exactly what the criteria are for you being able to get your data back. It's not nebulous. It's real, and it's just, quite honestly, safer and more available than anything any law firm could do for themselves.
Yeah, that's exactly right. And I think a lot of people fail to actually do the diligence that they need to figure that out. I tell a lot of people, hey, look, the cloud is safe regardless of how you do it, as long as the company that you've investigated is doing certain things. Now, these guys would not be in business or continue to stay in business, either LexisNexis or any of the other case management software companies or any of the cloud storage companies. They wouldn't continue to stay in business if they had continual failures in protecting client information, if they had leaks upon leaks upon leaks. And so they do a lot of diligence, probably more than we do in our individual practices.
There's no probably about it.
Than we do to keep our own data safe. I think it's just kind of ludicrous. The other thing that we fail to look at too is we've started using mobile tech in a lot more ways than even we did, say, 4 years ago or 5 years ago. The invention of the iPad really changed the way that lawyers in particular do a lot of work. Now, I talk about Android in mine, but the same principles apply. And once you start using those, you've got an obligation to understand how that works and what the information is and where it's being stored. And there's so many things that you can do to improve your law practice, but you need to know what the risks and rewards are. One of the things I like about mobile, cloud, software as a service type things, law practice management, helps you avoid conflict.
Absolutely.
If we were talking about this before as we on a deal, if you're collaborating together on the same document and you know where everybody's been and what they're doing, Google, Microsoft both have cloud collaboration products, but if you're collaborating, it's a lot less likely that you're going to get into some big argument about what needs to be said and where it needs to be put when you're working together. The problem is when you have 7 different documents and you're trying to figure out what the document is and the file is and which one's the newest file among the 27 different versions that you have. We've all experienced the same thing when we have paper documents and we look at the paper documents and we can't remember, is this the most recent draft that we've revised and everything? Cloud really helps put that to rest, and especially cloud practice management software. And being able to search and combine and the biggest thing is being able to put relationships together and associate relationships helps bring a lot more productivity to your cases than just simply using a default search and find feature in Microsoft Word or some other product.
Sure. So and you've written using the word conflict here in the context that you have also brings up the to me. One of the bugaboos of small practice, which has been over the years, the difficulty in running and performing and logging and documenting meaningful conflict of interest searches to avoid, within a particular firm, to avoid violating the model rule and every state's actual ethical rules against attorneys having conflicts of interest. What about the technologies that we've been discussing, particularly case management technologies, from your perspective, really help to avoid these conflict of interest problems?
Well, because technologies, case management in particular, create relationships. When you enter the information into the database links that information together. And so when you do a quick search, you only have to search one spot. Most of the case management software is complex enough to be able to link all that information together in one place. Whereas, somebody who decides they want to manage their cases with Microsoft Outlook and an Excel file or a Word document that they create, that simply just doesn't create those massive relationships. Now, for a solo firm, you're probably not going to run into too many conflict issues. You're going to remember the clients that you've represented and maybe the people that you've talked to on a phone call or two. But for larger firms, small, mid-sized firms, you're going to run into and likely run into a lot of conflicts where, somebody's brother-in-law is the defendant in a case you can't represent them and things like that. And so those help determine those conflicts, and everybody can run the same search and see the same results. So I think that, that's an important aspect to being able to leverage that technology and avoid a lot of problems down the road where your firm may have to withdraw from a good case because you didn't do your diligence to start with.
Yeah, exactly. And I would also recommend that, in choosing good case management software, one of the questions that lawyers should in fact ask is, does your software do conflict of interest search, and does it preserve the search existing as it did when you did the search, so that I can defend it, if somebody claims 3 years, 5 years, 6 years from now that I had a conflict in a case, I can show the search that I did and the results that I got. I think that's absolutely key, Jeff, so thank you.
Yeah, no, that's a great point, too.
Cool. So we've got, sorry, go ahead.
I say there are a bunch of different tools to understand. We kind of talked about this. We got CLEs, and we got ways that we can learn. I love going to ABA Tech Show. It's a little more expensive to attend. It's in Chicago every year. This just happens to be from one this year. But this is a legal technology focused conference that you're going to learn a lot of stuff. And they have different tracks. And so, CLE events are great. I think a lot more bar associations need to do, either half-day or smaller conferences that are focused on helping people understand technology and use technology in an efficient way. That we can't read everything and we can't know everything, but we can certainly do different projects and different things to understand where the technology is going, and CLE is a great way to do it. My favorite.
Yeah, sorry, I was going to I'll let you talk about blogs here in a second. I totally agree regarding ABA Tech Show. And then what I would also recommend for lawyers around the country are, definitely see what you can do to make the investment to get to ABA Tech Show, and then to get to either, that would be my number one for solo and small firms. And then Legal Tech, either New York or Legal Tech West Coast is another great resource. The ABA's shows, the GP Solo event, their annual meeting, is absolutely fantastic, and it also offers a year's worth of CLE as part of the program. So certainly recommend that. And then I can't recommend more highly, almost every state now is running a solo and or small firm meeting every year, in which technology is usually featured as a big part of it. And I've gone to probably half the states' solo small firm conferences, and they're an amazingly good resource. Lots of great people come around to them, lots of great speakers, and lots of great technologies are showcased there as well. And if you do 2 of those a year, I think you've got a good chance of staying on top. And then, of course, you were going to talk about ways to stay current online.
Well, yeah, I'm going to second your recommendation on Solo Small Firm Conference. You could be a big firm lawyer and go to the Solo Small Firm Conference and gain information that you need. And I think a lot of the problem with the bigger law firms is it takes a lot of movement to get anything to actually move. But with solo and small firms, you can move a lot faster. But just knowing the information gets you there. I'm a blogger. I have a website that I blog at, thedroidlawyer.com. But there are a ton of different blogs. I've listed a couple here. A couple of my favorites: iPhone JD, Future Lawyer, Lawyerist. Lawyerist is a good all-around blog. Attorney at Work is one of the better blogs on, just everyday putting out some information. And if you like Acrobat or use Acrobat, I can't recommend Adobe's Acrobat for Legal Professionals blog any more than my own. It's just simply a fantastic blog. But, the great thing about blogs is these guys are talking about the topics of interest, of importance on a daily, sometimes, weekly basis, whereas your bar journal or your conference is only getting that information once or maybe twice a year, on a monthly basis if you're lucky. And so bloggers really have that thumbprint on the future of technology and where it's going. And I think you're probably getting as much information from a blog than you would be from going to a conference if you stay on top of it.
Absolutely, no, they're absolutely key. If you can do news feeds, you can really keep up on that stuff. Sometimes it can be overwhelming, and I still find the conference is a great way to sort of aggregate that stuff.
Yeah.
But yeah, these blogs, the ones you've listed, I would second as great resources, especially the Droid Lawyer. Absolutely.
That guy's pretty good. Yeah, if you're and if you're looking at people get overwhelmed, the easiest way, most of them have RSS. If you look at RSS and Google, there's tons of ways to stay on top of the blogs without having to visit them each day, and so it makes it easier. And that that leads into the next part, which is firm compliance. Everybody, we talked about this just briefly, but everybody's got to be on board with what's going on in your firm. Right? For a small solo guy, it's easy. Look, I'm my own guy, and so I don't have to do anything other than what I want to do. But for bigger firms, everybody needs to be on board with what needs to happen, with the technology that's being implemented, with the information that we're adopting. Otherwise, you either get one or two bad things. You get no adoption whatsoever, or people start to rebel and start to form their own little cliques on how they think the technology should go and what should be allowed. One of the easiest ways, and that usually happens with mobile devices. Mm-hmm. I've talked to a ton of firms that are like, we cannot control mobile devices. We don't know how to do that. And I've got no way to say, look, this is the ultimate way to do it, other than to say, you need to establish your mobile policy. And probably 1 out of 50 firms have an actual written policy that says this is what our mobile devices are going to do, and this is how we handle technology. And that's the first thing. You need to have a written mobile device policy, but it also needs to be documented in what you do and how you do it. So there's certain features needs to be written. Everybody needs to have a copy. And if you're a small solo guy and you think, look, I don't need a mobile device policy because my mobile device policy is whatever I want it to be. Well, what happens when you die, or heaven forbid you die right away and nobody else knows how to get a hold of your information and where that information is kept? And so it should outline things like what to do in case of an emergency. It should also outline things like what devices we accept. Are we going to support every device in the universe, or are we only going to support Apple products running Apple iOS 7 or above, and Android products running Android 4.1 or above, and Windows products running Windows 8 and above? That's the kind of thing that every firm needs to think about, regardless of your size and regardless of what your features are. I think,
Jeff, I think you'd agree with me that there was a time, not that long ago really, where firms' IT policies in this kind of regard were, you will use this one thing that we say, this one software, and you will not use additional devices unless they're approved by us. And I think you and I would both agree that those days are gone, and that if you try to implement that kind of a policy, you will get rebellion and you'll get non-compliance.
Yeah, exactly. You'll find people. I think non-compliance is the biggest fact. People want to do what's convenient for them.
Right.
And it's not hard for firms to set up convenient access on most mobile devices and most desktop computers. And so, but they need to establish those rules and make sure that everybody plays by the same rules and has the same kind of game.
Right, and it just, if anybody, Jeff and I were just talking earlier about, don't get all panicky about the cloud. The cloud's real. You can know, as long as you do your due diligence, where your data is, how it's kept, how it's backed up, et cetera. But by the same token, I would suggest don't get complacent about the fact and the reality that these mobile devices are treasure troves of confidential information. You're carrying around in your pocket, if you've got one of the latest Android devices or one of the latest iPhones, you're carrying around gigabytes of information. I mean, when I went to college, gigabytes were like supercomputer dreams, and now we're carrying 64 of them around in our pocket. This can be audio, this can be video, this can be lots and lots of documents and pictures and everything else. And so having some policies around how these devices are secured, what kind of passwords, because they all support either having simple or complex passwords. Some of them allow no passwords too, and we have to have policies around, no, you won't carry one around with no password. And I would include, Jeff, because I don't think we've talked about it specifically, but I would include in mobile device policies around thumb drives and how those things are maintained, stored, encrypted, et cetera, because those, I find them lying around at least one a week. And you'd be amazed what I find on them.
Yeah, I think that's an important thing is, we're going to move more and more to people storing information on the cloud, so that's going to become a concern. But right now, I think a chief concern for everybody is, hey, look, how are we taking information from our office to a third location or a separate location, and that definitely needs to be addressed. You talked about
how would you recommend someone get started on writing a mobile device policy?
Well, I think that you need to address these three topics. Start by this: one, what kind of devices are we going to allow?
Yep.
And go the gamut of the devices that you want to allow. If you want the latest operating systems, then make that. Second, you tell what kind of security. Here we're talking about the security that's involved, what's maintained, and what's required on their device. If they're going to access the company resources, then we're free to set up security methods to protect our resources, and most IT departments can set that up, and if they're any good. I say, look, if you're going to secure something, you need to use pattern, password, or PIN. Now, pattern's not available on iOS, but it is available on Android. Password's the most strong, a PIN's next most strong, and a pattern can be set up. But you need to set what kind of security protocols will we have? How long does your pattern or your password or your PIN need to be? In my case, I would prefer everybody have like a 14-digit password, but that's not convenient for most people. So you've got to balance that.
For everybody listening to this webcast, can you just describe a little bit more what pattern is?
Pattern, if you on Android devices, you have the ability to draw a pattern. So if you want to draw the letter M, you can draw that as your unlock code. So when you unlock, you draw the letter M, and it will unlock your screen. Now you can set the pattern to be whatever you want it to be. And you can set it as easy, like a letter L, or as complex, 17 different squirrely marks all over the screen. You just got to remember that every time you unlock your device, you're going to have to remember the lengthy code. And that's the thing is, we sometimes surrender security for convenience on our mobile devices. And so,
and I actually noticed that there's a fourth one. I think that it doesn't start with a P. I've been trying to think of a. Oh, yeah, sure it does. Print. But biometrics.
Yeah, well, and that's going to be, as Apple's already set that, and that's going to be the future, I think, of how we're going to be accessing our devices. That fingerprint, it's not quite 100% with the iPhones, but it's pretty dang close. And being able to get those biometrics set up to secure, I think will change the way that people look at it. I think I tell everybody, look, use passphrases. Use something that you can remember that makes it easy to remember. If everybody used a passphrase as their password, we wouldn't have 1, 2, 3, 4, 5, 6 as the most common password, or password is the most common password. Something easy to remember. It's difficult to guess. This would probably take a computer 1 billion years to figure out what it is and go to it.
Yeah, and I would also recommend, because I totally agree with that. And then, for people that are concerned that they will forget them, there are some secure password vault applications where you can keep your passwords in a password-protected location.
Yeah.
For retrieval should it be necessary.
Yeah, exactly. LastPass is my favorite. It's easy to use and goes across all your devices, including your desktop. So anytime you need to remember a password, it's easy to use. The final thing I think in a policy should be what's going to happen if somebody leaves. You know, how do you destroy the information on that person's phone or the access to that person's information when they leave the firm? Because what happens a lot of times is somebody gets a new job, they go from your firm to somebody else's firm, but they still have the information that's on their old device. And so if we don't have a thing that says, hey, when you leave this firm, we got permission to go and wipe your device clean, and if you don't want that, then you better not access our firm resources with this, or you give us the opportunity to clean off what we need to, then we've got a problem. We also need, just once again, what do you do if you pass away and you're the only sole practitioner? Who knows your passwords to your desktop computer? Who has access to your bank account? Who knows your client files if you're using a cloud service or a case management software? Who knows all that information? Where is that information kept? I know we recommend against writing it down, but somebody, you know, my wife, there's an envelope in our safe at the home that my wife is supposed to give to our bar association if anything bad happens to me. That she knows what it is. It's sealed. It contains information regarding, you know, the firm here that they would need to be able to continue rolling on with my cases and represent my clients.
Which I think you brought up a great point, Jeff. So not only do you need a policy, but you need to actually share it with people.
Yeah.
But you know, it sounds trite, but it's true, right? It's, you know, we need to, like, our policies, when we're working with lots of different people, then the policy, of course, it was known by lots of different folks. But if it's a solo or a fairly small firm even, having these policies be available, like you said, should something happen, so that other people will find them and be able to figure them out, is important.
Yeah, exactly. I think that's, you know, it's key for any firm. You know, we also talk about needing the security, and this is part of moving to the cloud and using cloud providers. You know, NSA shook up everything by giving information to, you know, major telephone providers, and pretty much every cloud provider has a backdoor to the NSA. And so when we talk about using mobile devices or using cloud services, we need to talk about being secure. You know, remember that guy, Edward Snowden? He kind of shook up everything.
Yeah, but so, and then I threw this slide in, and because I wanted to also suggest that we always have to balance, because I think, you know, it's easy to get afraid of the NSA. It's easy to get afraid of you know, other guys like Jeff Snowden who haven't come out. It's easy to worry that there are prying eyes looking at everything, and to try to really lock stuff down. Well, you know, I can tell you how to lock your computer down so that it's safe. You know, unplug it from the wall, pour concrete onto it, throw it over, you know, throw it into a bank vault, and then throw it into the water, and that thing is going to be safe. Nobody's going to get the data off of it. But it's also not particularly useful. You know, if we pull up all the drawbridges, we become isolated, and we cannot help our clients. And after all, you know, law firms are in the business of selling and delivering legal services, which at the end of the day means that we're in the business of helping people. We're helping people in businesses. And if we pull up all the drawbridges, we can't help anybody. So the idea of leveraging technology and doing what Jeff said earlier about doing your due diligence and understanding the vendors and understanding the rights and obligations that they have and matching them up with the rights and obligations that we have to our clients is absolutely important, because we don't want to become a moat. We don't want to become inside the moat. We want to be reasonably concerned, but let's face it. If James Bond or the NSA or somebody else is going to come calling at the data centers, our job is not to absolutely positively prevent them from ever possibly figuring out a way to gain access to our data. That horse is out of the barn. Whether you store your data in the cloud, on your computer, or quite honestly in your file cabinets, that horse is out. What our obligation is to do what is reasonable, to exercise and do our best efforts to do what is absolutely reasonable to protect our clients' data against the most common threats. And I'll tell you what, and Jeff, I think you'll agree with me, most people aren't even doing that today.
I would wholly agree. You know, the rule doesn't say protect it like Fort Knox. The rule says use reasonable efforts to protect client data. You know, if you've investigated the company, they've got a good reputation. For instance, you choose Google because you like their reputation, you like the information, you understand where the data is being held. Well, then you've done a reasonable effort to protect that information. And at some point you have to actually trust the vendors that you do business with to live up to their side of the agreement. If it's always a one-sided thing, it's never going to get done. We can do certain things on our own too. There's encryption, which is just basically taking the information and locking it down in such a manner that nobody can read it. I'll recommend, I like this Vivo. In fact, I'm wearing this shirt today. If you haven't used the product, it's great. You take a file, you drop it into a little Vivo folder on your desktop. The program encrypts it, saves it up to the cloud. You can share it with anything, and it's encrypted. The only way that somebody can open it is if they have the Vivo information and your particular key, and so you can share it with all your devices. I use this if I'm going to upload medical records for clients to the cloud. I'll encrypt it. I'll look at them on my laptop at home or on my tablet, and they're encrypted. I know that the only way that somebody can open it is by this. Now, is it foolproof? Probably not. Is somebody going to be able to get to it? Yeah, but am I doing a reasonable effort to take care of it? Yeah, I think that's all I can expect. Somebody can crack it, but I've done what I need to do to protect the information.
Right, and I've seen it there, and there are some other other ones as well. And I'd just like to take a second and describe the two kinds of encryption, because I think it's another place where people get a little bit confused. There's the two kinds of encryption we all need to worry about are encryption in transit and encryption at rest. So encryption in transit means, when I'm transmitting my data, I'm going to share a document with Jeff, right? And so I could email that document to Jeff. Now, I have to worry about, on my computer, was that document encrypted before it left my computer? If the answer is no, then I also have to worry about encryption in transit. As I was sending it to Jeff, or as I was uploading it to my cloud service provider, either one, was that transmission encrypted? Now, with my cloud service provider, if I'm using secure socket layer, which is when you go to a website that says HTTPS, or when you go to a website it has that little lock symbol next to it, that means that that data is being encrypted in transit. So as it's floating through the internet from you to its destination, it can pass through 6, 12, even 18 servers on the way. Was it encrypted as it was floating through there? If I emailed it to him, was it encrypted as it floated through the emails? And I'll tell everybody right now, emails are not encrypted in any way whatsoever unless the file that you sent was previously encrypted using a service like, in fact, Vivo. And then so at my computer was at rest, in transit was as I sent it, and then it goes to at rest again. So if I'm using a cloud service provider, is it being encrypted by them where they store it? And those are really, really good things to be concerned with. What Vivo does is sort of takes that all out of the equation, because if you encrypt it from the get-go and it stays encrypted until somebody else decrypts it, then it's encrypted in transit and at rest. And it stops us from having to have the conversation about, is Dropbox secure for lawyers? I have a position on that. We don't have time to go into it. But you can get away from having that discussion and from having to choose the more secure cloud service providers like Watchdocs, for instance, or some of the others, or Google for Business, et cetera, by saying, hey, I'm just going to take care of the encryption up front. Now, on the flip side, the danger is if you lose your key, if you lose your password, you might be SOL. Because it is very, very well encrypted. And while Jeff has some confidence that someone could break it, let me tell you, if someone can, you're going to pay a lot for that. So there are gives and takes to doing encryption that you own. But either way, the real thing to come away with is make sure it's encrypted in transit, make sure it's encrypted at rest. How you do it, we could spend another 4 hours on.
Yeah, exactly, and I think people need to understand that. And this is, I want to tell people about this other service. It's in beta right now, but it'll be available here in the next few months. But it's called Virtue, and what this does is link to your Gmail account or your Microsoft Outlook or Office 365, and this will encrypt email messages at rest and in transit. And so the only way that, and it handles it in a particular manner, but Virtue is a definite go if you're looking for a way to encrypt your email messages and to send a secure message to clients, and everything that's in the email is encrypted with the email. So your attachments are encrypted, the message is encrypted, and the only way that they can look at that is if they're the person that's supposed to be receiving it.
Great. Well, this is the part of our presentation where we will open up to questions and answers. Everybody that's on the webinar has a on their right-hand side of their screen, I think, or for most people it's on the right-hand side. But anyway, it has a little control panel where you can see where there's a pane there called questions, and you can enter your questions there. Our hosts will see those questions and then get them out to us so that we can answer them about any of the topics that we talked about, or quite honestly about anything to do with legal technology and how, particularly how we can leverage legal technology to meet our ethical obligations under your state's rules or the model rules of professional conduct. So yeah, just go to that question and answer pane and post up some questions, and we'll be glad to answer them. While we wait for folks to do that, let me ask you just we kind of talked early on about paperless, and I talked about it for storage. But Jeff, can you just address how other ways that lawyers can benefit from having a paperless office?
Well, I think the biggest way is being able to search or quickly search through the information. You know, for instance, I have that 1,000 pages of medical records. If I convert them into digital format, PDF, I can make it so that they're searchable and have optical character recognition, OCR, and that way when I type in a word, for instance, you know, fractured leg, I can find every instance that occurs, and that makes it easy so that you don't have to work to death, review every single page for an instance, and you know it's about 90% accurate, and so you may miss one or two, but you get the gist, and it sure shortens the time frame that you have to actually do a lot of things.
Yeah, that's a great point. It basically takes piles and piles of paper and makes them into a searchable, retrievable, and powerful database. So that's a great way. We have a question from one of our participants. I'm only going to do first names. First name is Robin. And Robin asks, are you saying it is a reasonable standard of care to encrypt all email communication with clients now to protect attorney-client privilege? I'll let you go answer that first, Jeff, and I'll probably have some comments on that as well.
Okay, here's the reality. Your clients are not using encryption. Is it necessary for you to use encryption for every single document? Probably not. Is it reasonable to do it? Probably. Is it feasible to do it? Probably not. Realistically, there was a good point. Somebody who is very security conscious uses Gmail. And somebody asked him why he uses Gmail, and he said, well, because the person on the other end uses Gmail as well, so the information's already out there regardless if I use an encrypted product or not. My thought is the information that needs to stay protected should be encrypted. For instance, if you're going to send a recommendation that your client not take the plea deal, and because A, B, and C, then that probably needs to be encrypted so that other people don't see it. On the other hand, if you're just confirming that we're going to meet at the courthouse at 1:30, is that okay? That's not an important or essential message that probably needs to be encrypted. So I think that the reasonable approach is to take incremental aspects and figure out what's going to need in the future, what will we need to preserve, and how will we need to protect it.
Yeah, so I mean, I totally agree with what you said. So yeah, it's probably not going to be everything. We do have to pay some attention. I think take some care to say this is a privileged communication. This is less of a privileged communication. You know, should I park in the back or in the front? Probably less of a privileged communication, unless you have a client who's likely to get shot at, in which case maybe it is a privileged communication as to where you're going to have them park. You know, you got to have some discretion around that. But to the point, Jeff, because I hear that a lot too. Well, you know, my clients are sending it this way. we constantly, as attorneys, have a duty to teach and train our clients about attorney-client privilege. They don't get it, right? They don't necessarily understand that if we meet them in a restaurant and that we sit in a booth with people behind us and in front of us, and they tell us stuff that it is not privileged. That if other people overhear it, they're basically waiving their privilege. They don't know that. There's no reason for most people to have that level of sophisticated knowledge regarding attorney-client privilege anymore than I have, particularized knowledge of how to properly do my taxes or how to fix my microwave. There's
Exactly.
it's different specialized information. We do have a duty to train our clients. So if our clients are getting into the habit of emailing us stuff that is actually a privileged communication through a medium that might not be privileged, whether it be email, or carrier pigeon, or using a telephone in a public place or a cell phone in a public place, whatever it is, we have a duty to train them not to do that. And if we are aware of, and it's easy to use, a simple technology like this Virtue, which I'm going to try, and it becomes easy to use. I think as a law firm, if you fail then to provide that to your client to communicate with you, you might not be doing what's reasonable.
Exactly.
So, yeah.
A lot of these management programs also have back-end client communications that are secured, and so you can use the back-end side to send messages back and forth to each other, which are secured. The other thing is that we often forget. We're so worried about the attorney-client privilege, but we need to remember that the attorney-client privilege doesn't rest with us. It rests with the client. The client is the only one that can waive that privilege. So, like you said, we need to educate them on what that means. Let's not meet in Panera to talk about how you were gonna defend your rape case. Rather, let's meet somewhere else. But merely us sending a communication back and forth, if it doesn't necessarily waive the privilege, the attorney-client privilege. It's only the client that can waive it on the other side.
Great. And I think we have time for one more question. We've got Dale. And Dale asks, there we go. Will there be a list of encryption and other resources discussed available somewhere? I'll let you answer that one because I think you've got the power to make that happen.
Yeah, I can list it. The two programs that I'd recommend for encryption right now are Vivo, V-I-I-V-O, and Virtue, V-I-R-T-R-U. I've tested both of them. The Vivo is made by the guys who made the zip file, and so they know encryption. If anybody knows what zip is, that's who did that. Virtue is a new company, but being able to encrypt your Gmail account is awesome. It works across Google Apps, Outlook, and regular Gmail.
Yeah, and to that end, what I'll say here, and I'll let you do this, Jeff, is I think there may be additional things like that people will want to know and want to be able to continue this conversation. So, Jeff, why don't you give out your Twitter handle so people have that?
Yep, it's at Jeffrey, Jeffrey _ Taylor, Taylor, or you can also catch me on Google Plus, which is plus Jeff Taylor.
Yeah, and through that you can follow Jeff using that Twitter handle or the Google and see the stuff that he posts and ask questions like this. You can also follow me at my Twitter handle is at @lawfirmbusiness. Follow on there or ask additional questions. We'll refer you to the blogs that have information like this as well. And of course, at LN Firm Manager, our hosts and sponsors, they will be retweeting and we'll be retweeting their stuff. So we'll be able to do that. I think we've got time for this one more. And this one is actually for our hosts to answer, I think. Will a summary of this webinar be provided so we can reconsider the options for encryption? Also, if we encrypt on our end, how does the client or other recipient decrypt on his end? So that's two separate questions. So I think I'll answer because I believe LexisNexis will be posting this webinar as a webinar on demand in the future. So you'll be able to access it there. If you want specific recommendations, again, follow Jeff at Jeffrey Taylor or follow Law Firm Business. Follow also at LN Firm Manager, and we'll all retweet that stuff. The second half of the question is, if we encrypt on our end, how does the client or other recipient decrypt on their end, on his or her end? And Jeff, since you were talking about encryption, I'll let you go for that one.
Yeah, with Virtue, you actually, when you get an encrypted message, it'll actually say you need to click here to unencrypt. And so Virtue handles the encryption on their side, which causes some concerns, but I've talked to the guys and feel confident with what they're offering. With Vivo, if you have a Vivo and the key, then you can unencrypt the information or decrypt the information by using the application. The thing I like about Virtue is that you don't have to have any special tools to decrypt the file.
Great. And so they would have access to the same thing and be able to decrypt it in that way. Obviously, there are other applications for encryption and decryption. All of them have a recipient. Even if you're the only one that's a licensor, they always have a recipient's method to decrypt, and then depending on the different kind, you share your key with the recipient in different ways. They can pre-set it up with you. There's a lot of different ways, but the instructions are always found in the encryption side of it.
Yeah,
we have reached the end of our time. So Jeff, I want to just thank you. It's been a pleasure, as it has always been, talking with you.
Thank you very much, and thanks to LexisNexis for hosting this and having me.
Exactly. Yeah. Thank you. And I was also going to thank LexisNexis for a manager for sponsoring this webinar. You've gotten our Twitter handles. You can also catch an interview between Jeffrey and myself at the Legal Talk Network at the show The Unbillable Hour, so you can learn more at that location as well. But for now, I'll pass it back to David Honecker with LexisNexis with my thanks and gratitude for hosting this webinar.
Thank you again, Chris and Jeff, for, as always, your fantastic insights on this topic, and especially thanks to all of you who took time out of your busy day to join us. If you'd like to access this webinar, as Chris mentioned, if you want to see it all over again or share it with a colleague who wasn't able to attend, we'll be sending out a YouTube link in about a week or so for your viewing pleasure, and we'll also include the deck from today's presentation.